I was on S.P Sinha. After that, my learned friend will continue with the others. My learned Mr. Muzumdar and Mr. Amajit is there.
Mr. Maiti is not here?
Who, Malad?
No.
Mr. Trivedi is appearing.
Trivedi, yeah.
Yes, Trivedi is appearing.
Trivedi is reading.
Mr. Dej. Oh, fighter though. S.P Sinha though.
You have completed, I think.
No, 5 minutes I have to ask. The Lordship can match.
1 o'clock, what is fixed? Your matter.
No.
No.
Continuation.
8:23.
Literature, sir. Oh, she got the Ashok Shah bolve?
No.
Closed by case.
Yes.
Well, first is, on the last occasion, I had given your Lordship the medical condition of Mr. S.P Sinha, who is 72 years of age. And, the custody period your Lordship has seen. Now, there are two things which I would say acts deliberately done by the investigating agency. I'll tell you Lordship why I'm saying this. I was first taken into custody on the 10th of August 22. In connection with RC case number 5. Right, my lord? Then, my lord, on my own volition, when I heard that I was wanted in another case, that is RC3, on the 9th of September 22, my lord, I was shown arrested and I was taken into custody in that case. Then, my lord, the best part was the case RC4, which is before your lordship also. My lord, I was shown arrested in that case on the 24th of March 2023. So, what I'm trying to impress upon your lordship, my lord, I am in custody since 10th of August 22. Now, my lord, what they are doing as things are going, like I'll tell lordship what happens normally. I'm shown arrested in another case. Then I have the right to take him into police custody again.
That's why you have.
That is why, my lord, they have been doing all this. Nothing has materialized in that, but the harassment part, my lord, the lordship is to appreciate. A 72-year-old gentleman is in custody. Well, let's accept he has done something extremely bad. Still, my lord, he has a right of trial, my lord. My lord, starting from Antulya's case, my lord, your lordship is aware of. Right of appeal also falls within Article 21. Not only at the investigation stage or at the bail stage. Antulya has made it very clear. Now, my lord, what happened thereafter was, my lord, Justice Basu had passed an order, which my lord was pleased to grant bail to Alok Sarkar. There, my lord, in the charge sheet, my name has also been taken. So, my lord, these three, my lord, what I'm trying to impress upon your lordship is, these three cases, which is pending before your lordship, we are in custody, or rather, we are all in custody for more than 2 months.
Alok Sarkar has been released.
Yes, your lordship granted bail last week.
Released from.
Yes. My lord, he was given a clean sheet by CBI. So he was released, my lord.
Right.
That is why. So, my lord, I was praying.
You received clean sheet from.
No, I'm in custody, my lord. How can I get a clean sheet here? My lord, I don't want to make it in a public way. What they are doing, my lord, I can't tell your lordships.
No, the main issue had not been brought.
I've said about 309. I'm
not been
answered
as yet.
Mr. Dwivedi has not answered that question of 309. So, my lord, I am in custody for more than 2 years, 72 years of age, and the medical reports I have given to you. I'm grateful to you.
Ashok Kumar Shah, he is also a septuagenarian. And on the last occasion that I have argued this case, that I have drawn your lordship attention to the order passed by the coordinate bench, granting bail to Dr. Kullanbhai Ganguly. I have said I stand on the same footing on which the considerations on which Kullanbhai Ganguly was granted bail, those considerations.
Dr. Ganguly is still in custody.
Yes, other case.
But he was granted bail in connection with this case.
309. What is 309?
My lord, production
of what?
Not
Production of the accused.
Not the remand of the accused after taking.
309 of CRPC or.
Yes, CRPC. Remand of the accused to custody after filing of the charge sheet and upon taking cognizance of the offence. Yet the special court has not taken cognizance.
You know, the consecutive date of trial or something like
that? No.
That is 390 and
Subsection
311.
309. You have said
309.
Subsection 3.
Your lordship has the old act.
Yes.
এটা সিআরপিসি দাও না তোমার কোথায় আছে?
এখানে আছে তো।
আছে।
ঠিক
309, please.
After taking cognizance, subsection 3.
Then subsection 3 you have to. Not 309 as your whole.
Subsection 3 to 9.
I will check.
First to postpone or adjourn proceedings.
Ah.
In every hearing or trial, the proceedings shall be continued from day to day until all witnesses in action. They are consecutive dates of trial.
Subsection 2.
But subsection 2.
Then you have to mention them. If after taking cognizance of an offence or commencement of trial finds it necessary to postpone. So there must be some reasoning to be recorded.
No, after taking cognizance.
Cognizance in 9. Remand করবে কি?
Why cognizance was
But sanction not given?
Then what is the fault of, whether it is fault of the prosecution or
Well, not my fault at least.
If that is so,
It's not
if
my
that is
fault at
so,
least.
You belong to state government previously.
no, it's all right. But
Then
that
then
is
the
so.
protection has to be given.
Then the
That is why
CBI
they have asked for sanction.
CBI could have moved a writ application, or this could ask
I
him
thought
for a
my
writ of mandamus.
Mr. Basu, this point of 309 applies to all the accused persons.
Yes.
Cognizance not taken.
Not
Excepting Partha Chatterjee.
Cognizance taken.
Take it. We take it.
Sanctioned.
There, but
That we
not taken.
cognizance not taken.
Action is in respect of
Yes.
हाँ, पार्थ तक बोल रहा हूँ, Dr. Chatterjee बोल रहा हूँ. I only one thing, the judgment which Mr. Ganguly has referred to, well, we all rely on the same.
हाँ.
Grateful.
Rest are the agents.
দাঁড়া, তুতুন বলবে? তুতুন আছে?
So you are for the state or?
মানে he saw one of the accused.
তুই কি করে দিতে চাইছিস? করে নে, করে নে, করে নে, না, না, কর না, তুই কর, আমি শেষে করবো তাহলে। I'll wrap it up. তুই কর না।
আমার করা নেই, তুমি করছো।
আচ্ছা,
আলাদা আলাদা মামলা দাদা।
Well, I am appearing for Dr. Subhiresh Bhattacharya in two matters. In respect of Dr. Kollanmoy Ganguly, in respect of one matter. Well, the only thing, well, with the permission of Mr. Mukherjee, I would only draw your lordship's attention to page 33 of the written of the memo of evidence supplied by them to your lordship, to your lordships.
কি memo of it? Evidence such.
এই যে এরকম জিনিসটা না আমাদের টাইম নেই, এটা সিবিআই দিয়েছে। Well, after your lordship makes it CAV, if your lordship permits my learned junior to
Please, otherwise
ensure the collation in the presence of someone from the
we'll be
CBI.
completely lost.
না না, জজ সাহেবদের ওই ফাইলগুলোতে ঠিক করে দেওয়া, আবার সব উলটপালট হয়ে গেছে, একটু থেকো একবারে
ওই
করে দাও।
আমরা সিএবি করে দেবো আজকে, ওদের কেউ একজন জুনিয়র এসে এদিক থেকেও এসে তোমাদের হেল্প করবে, ঠিক অ্যারেঞ্জ অর্গানাইজ করে দাও, লিখতে গিয়ে হাবুডুবু খাবো না হবে।
We have made it into 3 files, but only in respect of Partho Chatterjee and the Dr. Subhiresh Bhattacharya and Kollanmoy. The others I cannot. But your lordship will kindly see page 33 thereof.
নো এগুলো নয় বাবা,
এটা তো থাকবে সার্ভিস, এই যে এরকম জিনিসটা। হ্যাঁ,
আমাকে চার্জশিট হ্যাঁ মেটেরিয়াল পেলাম, চার্জশিট ফাইল মেটেরিয়াল পেলাম,
তোদের তোদের
কি বলিস আমি যখনই
এগুলো নয়, এগুলো নয়।
যখনই অভিযোগ এবার অভিযোগ দিতে গেলে
Well, just for your lordship, সেটা মার এই কপি আছে এমনি কোনো? Well, I can hand it over to your lordship. Well, just for the interim measure, may we just hand over this copy till it's found out?
we must have our copy.
তুই একটা দিয়েছিস তো?
জহর কোথায় গেল আজকে?
Well, if your lordship kindly takes a page 33. This is just from the part of clarification on behalf of Partho Chatterjee, with the
Yes.
permission, Mr. Mukherjee is not there anyway. Well, if your lordship kindly sees page 33, memo of evidence in RC 3A 2022-col. This is in respect of Dr. Partho Chatterjee. The difficulty is that we have not applied in RC 3. We have not been shown arrested by them. So therefore, I think they have done more than what is required of them. So your lordship will kindly ignore. Hey, we have not applied for RC 3. Partho Chatterjee.
In one case, you have recently taken custody in custody.
That is RC 6.
Soon arrested in another new case.
Yes, but RC 3, we have not been arrested. We have not paid for bail.
Then-
So this part of the memo of evidence, your lordships will kindly ignore. That's my submission. In excess, they have given.
ওটাই কি আছে তো কেন এসব পরে আমাদের ঝামেলায় থাকে?
Anyway, yes, then
Well, now coming to Dr. Subhiresh Bhattacharya in RC 3A, well, we have given a small response to the memo of evidence, so I will not trouble your lordship much. And this is the response with regard to RC 5. I've given the CRM numbers on top. We will arrange everything for your lordship. Yes.
বুঝেছো?
Only if your lordship kindly. What we have submitted here is that most of the arguments relate to periods of 2019.
Now, I had resigned as I had already submitted in 2000. I'd resigned in 2018 and I had been appointed as the Vice Chancellor of North Bengal University thereafter. So I was not with the West Bengal Central School Service Commission after 2018.
This is Subiresh.
Subiresh. All the submissions that they have made so far as Subiresh is concerned, it relates to a period of 2019 when he was not there. The other issues that they have raised are primarily which have been mentioned in the charge sheet under subject matters of proof. Well, merely on that, your lordship will consider when I am in custody for more than 2 years, whether I should be detained, considering the huge number of witnesses. Well, in their response, however,
How many witnesses?
well, there are about
137.
137 witnesses in each case.
Each RC.
The other thing that I would point out to your lordship, if the response is there before your lordship, if your lordship that I gather is of RC3.
Yes.
Yes. Kindly sees page 5. আর দুটোই তো দিলাম।
এটা
RC5 or RC3?
RC3. In both, it's the structure is the same. We have dealt with their responses, their allegations, and the response thereto by us. Your lordship will find 1, 2, 3, 4, and the allegations first, then the response by us. The only thing is at page 5, your lordship will see the conclusion and E
Conclusion,
and Roman E, English E, small e.
even if trial was to begin.
This, yes. And then E, that CBI has not preferred to respond to the arguments made on behalf of the petitioner, and we have placed before your lordship the issues that they have preferred not to deal with, because we had supplied them with the short notes of argument beforehand, before their arguments, and they preferred not to respond to the same. This is all I wanted to show to your lordship, so far as the two responses of Dr. Subiresh Bhattacharya is concerned. The other issues I have already dealt with by way of the response.
very well.
Well, with coming to Dr. Kollanmoy Ganguly, well, this is our response.
Now,
Yeah.
Subiresh টা না।
One.
1 p.m. একটা কি ফিক্স করেছিল one? Our matter, whose matter? 1 p.m. whose matter? Why did we fix it? What matter?
This was that matter of default bail which was refused. The LCR was called for. The charge sheet was filed after.
If we can't take it up now, we'll take it up at 2 then.
As per your
Let us see.
I'll take 5 minutes, Mala. Not even 5 minutes. Now, this is with regard to Kollanmoy Ganguly. Your lordship is aware that he is already on bail in connection with RC5 granted by this honorable court. That order has not been challenged before any superior court by the CBI.
That is Justice Bagchi.
Justice Bagchi's order. Now, what had happened, they had filed an application praying for showing him to be arrested, and they moved it immediately on the day the bail was granted by this honorable court, virtually defeating the order of this honorable court. But the same facts are there, my lord. The allegation is that I have issued the appointment letters as per the recommendation letters which were supplied by Dr. Sinha from the from the Central School Service Commission. I, being the president of the board, I had no other option but to sign it in terms of the gazette notification and the rules which were framed by the government.
It has been changed.
My lord?
Rule has been changed from previous rules.
Yes.
I mean,
And that was by the government. I had nothing to do with that. And as per that rules, I had to sign. There is an allegation that I have signed documents which are after the expiry of the panel. My lord, will kindly appreciate this compilation of panel, holding of examinations, and compilation of panel are the duties of the School Service Commission. They are not the duties of the board. The board is only the appointing authority as per the recommendation letters which come from the School Service Commission. Well, I do not wish to say it, but it's virtually like a post office. Whatever recommendation letter it comes, they are to sign it and issue it. In fact, it is the prosecution's case that these appointment letters were taken by Dr. Sinha and also Service Commission office. So far as this petitioner is concerned, his scanned signature only appears in the appointment letters. Beyond that, there's nothing. My lord, I have dealt with the responses. If your lordship kindly sees at page 2. The first argument was that we had conspired with the other accused persons and issued fake appointment letters. First of all, they are not fake. They may be irregular. They may be irregular, but not fake. They are not forged documents. Now, my lord, at the bottom of the page, we have also provided the rule by which I was virtually directed by that rule to sign whatever is given by the commission. And I have mentioned the page numbers also of the CRM where I have annexed the rule. And with regard to the second allegation is that
through this, Mr. Ganguly, we
Very
have
well.
to go through this.
I'm deeply obliged. My lord, only other thing I would again show to your lordship is at page 5.
Vacation reading, conclusion. I've seen the
Yes,
conclusion.
I'm deeply obliged.
Vacation reading for us.
My lord, I've tried to be of assistance as much as possible by putting it down
Yes,
in
yes.
written form so that your lordship can go through the
Hey.
same. I'll arrange it. I'll
Please.
arrange it.
Dr. Kullanmoy Ganguly file over.
My lord, so far as I'm concerned,
There are 5 more petitions. Lord, these petitioners are the agents. Lord, Apex court has granted bail to one Procedural Ray. Subsequently, one Krishna was a MLA. He has been granted bail, and one Pradeep Kumar Singh has been granted bail by this honorable.
Those
May I mention, my lord?
There is another person here. Calcutta Sinha Ray. Mr.
My lord, I am appearing on behalf of Ashok Kumar Shah in respect to item number 892. My lord, in respect,
already appeared.
Mr. Basu.
Yes.
Also appeared for him.
yes, my lord, Mr. Basu has appeared on item number 8902 specifically. I am also in that matter, but I specifically, on 892, I am appearing.
You will be
Item
appeared.
number, yeah.
What do we have to add?
my lord, my just submissions, only one point is there for item number 892 in respect of the Ashok Kumar Shah. That is, I was in interim bail by his lordship on 24th May 2024 regarding on humanitarian ground. And for the particular 7 days, I was granted interim bail. In respect of 7 days, my lord, no adverse report against me by the CBI authority has submitted. That is my submission. And another submissions, my lord.
No. Interim Very well. We'll keep that in mind.
And my
You
lord,
are-
one another submissions, my lord. I also refer the section number 309 of subsection 2. For the particularly,
Basu has.
yes, senior counsel has already submitted. I pray for the bail.
All right. Yes.
Yes.
Right. Top court, the hearing is concluded. Right.
Yes, but one thing
Yes.
more, we don't require sanction. These petitioners don't require sanction, and the 309 that issue will also apply for this.
Hearing is concluded. Judgment is reserved.
My lord. Yes.
Thank you, Mr. Trivedi.
Well, two aspects, my lord. I'm reading 309 one time and again. I'm very. The 2 points have come. First, my lord, I was thinking that, my lord, they will not make submissions on facts.
I have not made.
My lord, submission. My lord, if it is so, my lord, submissions on fact have been made, but I don't want to elongate and prolong the entire thing again, coming again, my lord. One. Secondly, my lord, as far as my learned friend has said, my lord, whatever we have already given on record by way of our written submissions, they have also given. I'll be repeating and reiterating the same, my lord, though I have reserved my rights because some statements were submissions were made on facts. One. Now, my lord, 309, my lord, if my learned senior friend.
309 2, subsection 2.
309 subsection 2, my lord, my reading of the section, if I am having the right book.
There is no decision on this, judicial decision.
Well, in fact, there is a decision of this honorable court where this honorable court held it to be illegal detention and released the person. I think Mr. I'll try to. Well, the thing is that under 167(2), the learned magistrate cannot remand any person beyond 60 or 90 days.
Correct.
So the only other power of remand is under section 39, which comes after the taking of cognizance. So if cognizance is not taken,
39.
309. I'm sorry, man. So the only other thing is 309. So that requires taking of cognizance. So unless cognizance is taken, the magistrate cannot do it under 167(2) any further. So he has no other. So the detention becomes illegal, and therefore
All right.
that is the perhaps the argument which Mr. Basu is trying to.
All right. Yes.
But that's why that's
Just a minute for remand. So there is a separate chapter.
Yes, 167.
But 309 is general provisions as to inquiries and trials.
Yes,
You have to answer these.
this is at the stage of inquiry, my lord.
Remand portion or arresting.
My lord, whenever a person is remanded by the learned magistrate, it is as per a statutory power.
67, I think.
Yes,
167.
your lordship kindly sees 167 then.
এটা তো 60 days, 90 days beyond
হ্যাঁ,
পারবে না।
পারবেন।
তো এটাই বলছে তারপরে হলে the only way you can remand is 309 subsection 2. আর তার জন্য you need to take cognizance again.
May I just point out to your lordship 2A, 167 2, small a. Your lordship has the book,
Yes.
the old one.
Yes.
May I place it? The magistrate may authorize the detention of the accused person otherwise than in the custody of the police beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so. But no magistrate shall authorize the detention of the accused in custody under this paragraph for a total period exceeding 90 days or 60 days, and on the expiry of the said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail if he is prepared to. Now, therefore, under this chapter, he cannot. Then the only other provision under the CRPC which permits the learned magistrate to remand a person is only under section 309.
Then in that case, there is no limit. 60,
Yes.
90, 120,
No, no.
nothing. There's no limit.
So once cognizance is taken, the controlling words of section 309 is taking of cognizance. That is what Mr. Basu was submitting.
Now you have understood. Now you
But
answer.
I've understood. I've understood.
Yes.
I've understood very
You have
well.
accepted.
What cannot be done directly is being tried to be done indirectly.
Yes.
That is my befitting answer. And secondly, what was said that I am answerable. But I'm not answerable. I am representing an agency. I am not representing the judiciary. So therefore, I vehemently say that I am not answerable as far as 309 is concerned. So such thing coming from the bar is uncalled for. One.
No.
Secondly, Millard, as far as 309 is concerned, Millard, it is what my understanding of the statute is this, Millard, that 167 already, the period is of 15 days. Now, Millard, after charge sheet is submitted, and then if during inquiry or trial, now, Millard, here trial has not begun, admittedly. Reason being, the charge sheet being filed, sanction has not been given, so charges could not be. Now, charges could not be framed, then the provision they are saying, they are trying to take advantage of their own wrong in a circumvent manner. And Millard will kindly see if the clear reading of the section, if my Lord kindly sees.
Now it will give a bad precedent also. It will give a bad precedent that sanction is not being granted for numerable occasions.
My Lord, that is, my Lord, what I'm very humbly submitting before my Lord, if my Lord sanction is not being granted, my Lord, speaking very categorically and straightforward, the petitioners are not responsible because it is for the state government. So we cannot say that they are responsible. It is something which we are trying to assume and presume, which straight away in this application for bail, my Lord, I cannot champion for that. But my Lord, what I'm humbly submitting is as far as 3092 is concerned, my Lord, what my learned senior friend is relying upon, that how the learned magistrate could remand, without framing charges or without, my Lord, taking cognizance. So, my Lord, first the cognizance will be taken, then only, my Lord, the other. Now, my Lord, here, my Lord, if I read, my Lord, my understanding, my Lord, if the court, after taking cognizance of an offence or commencement of trial, finds it necessary or advisable to postpone the commencement of or adjourn the inquiry or trial, it may, from time to time, for reasons to be recorded. Now, my Lord, it is said that this power has been given to the learned magistrate only after the cognizance is taken. Now, my Lord, cognizance has not been taken, so he does not have the power to remand now, my Lord, under those circumstances, my Lord, whatever has been done by the magistrate, it is for the magistrate. My Lord, he has taken it. That is what I'm humbly submitting. My Lord. So I cannot answer for what has been done by the learned magistrate being from.
No, you're right. You're right. We have followed. That is all, Mr. Trivedi.
No, my Lord, I cannot continue.
Yes. So hearing is concluded. Judgment is reserved.
I request one thing.
Kindly organize the fights.
Well, definitely.